So if you've been living under a rock the past few months, you know about Nick Sanmann. Is that how you say his name? Sanmann?
Sanmann, whatever.
Was the young man that was in Washington, D.C. with his school, and it was a Catholic, apparently a parochial type school. And we don't need to get into the details of what happened, but basically there was an incident, and there's fingers being pointed who did what. And if you don't know what's going on, go back and read about it. But here's the issue. The issue is he's claimed that he's been defamed by the media and by a number of celebrities who tweeted out and said things that were clearly, to some degree, clearly meant to defame him or harm him in some way. There's a couple of issues we're going to look at here. The first issue is venue, and we're going to talk about venue. The other issue is defamation. And we've talked about this last week, Todd. We're not going to get in deep details, but clearly there are certain rules in defamation. If you are a known public figure, the amount of proof that you're going to have to bring forth to go after someone for defamation is extremely high. That's all I can generally say. But as a minor child and not, at least at the time, a person that is well known or a person that is a public figure, which Nick was not at the time, the scrutiny is much lower as to what you have to prove. Okay, and so here's the issue. The issue is he hires lawyers, and they're going and they basically put everybody on notice that defamed him, basically with money, and said, we're going to go after you for defamation unless you recant and say, hey, we made a mistake, because there's been investigations showing that what was put out in tweets and on in newspapers, etc., is not entirely true. So I said 350 so the owner of Amazon, Bezos,
yes,
bought the Washington Post for $250 million.
That's right.
And he sued for $250 million the amount for defamation. Is that right, Todd?
That's right. They have picked an amount that equals the purchase price of the publication.
So that is going on, and they never said anything or never came back and apologized or recanted or did anything. So guess what? After the lawsuit occurred, and by the way, they have claimed they are bringing in more people in this lawsuit that did not recant and by the way, Kathy Griffin was one that did recant and said she apologized and sorry. And I bring this up 100 times, a million times, that's an exaggeration, a lot of times.
Several times,
3 times.
No hyperbole here.
But it's because the social media thing, it just gets out you're guilty until proven innocent.
Yeah.
Because it's just boom, it hits the social media and it's all over the place.
And the person who gets the message out first controls the story. That's the key point, right?
Exactly right.
Because this was an edited clip. It went out and only showed a little slice of what had actually gone on. The Washington Post, in their non-apology, what they call an editor's note. They didn't even apologize.
I love that.
They called it an editor's note. That's their way of saying, well, we're
forced. Our lawyers are forcing us to do this.
Right. And we don't want to, but we will. So they didn't even apologize. But the simple view of this should always be, if you're involved in a situation, get in front of the story. Get out there on the cutting edge of it, and don't let other people decide what's going to be said.
Well, just as a refresher, I'm going to go over really quickly what the elements for defamation are. Now, look, this is a general statement. What happens in individual states, everything's relatively close. But the first is that the plaintiff, in this case, Sanmann, or the parent suing on his child's behalf because he's a minor.
He's 16, I believe.
He's 16. They have to prove that the defendant, Washington Post, made a false or defamatory statement about Sanmann. That's the first one. Second, that they have to prove that the defendant, the Washington Post, made this an unprivileged publication to a third party. So posting it in your newspaper would clearly qualify. Third, that the plaintiff has to prove that the publisher acted negligently when they made that post or that statement. Okay, and fourth, in some cases they have to prove special damages. Now, the thing that is difficult for me to comprehend on the part of the Washington Post is that by the time the unedited portion of the video came forward, it was clear, crystal clear, that the original story that they had posted was not correct. Okay? It was not correct. Now, there is nothing in the elements that I just quoted here that says that offering an apology will negate the elements of the lawsuit.
Well, there are. If you're a public figure, then the scrutiny's higher, though, on a defamation case.
It's higher, but there's nothing in here about there being, if the accused party apologizes, well, then that's an affirmative defense and this lawsuit goes away. Right?
Right.
So there's nothing here that says that. But the plaintiff in this case, before filing this lawsuit, sent letters to everyone that they intended to sue saying, if you apologize, if you do something, we will back down. And Washington Post, still knowing that their story originally was false, did not take them up on the offer to apologize to avoid a lawsuit. So now you get $250 million lawsuit filed, and you get this half you-know-what statement in the editorial trying to circumvent it, but
which we're going to talk about.
Too little, too late.
That's what the lawyer said.
Yeah.
That was the exact reply of the counsel to the Washington Post, Fred, what he said, too little, too late. And the kind of apology you're talking about is one that is neither slow nor fast. It is a half-fast apology.
That's right.
Yes.
Half-fast.
Yeah.
Well, it goes back to what Washington Post is probably saying. It's a freedom of speech issue, freedom of the press. That is what they're probably hinging their argument on. And their original statement after the lawsuit came out is, we're going to vigorously oppose this. Well, again, they came back with a half discussion, and let's talk about what the half discussion, I'm going to say,
yes,
and leave out another adjective.
Well, it's not. It's fast. It's HALF period or space FAST.
Neither slow nor fast.
Yes.
Yeah. Editor's note in full. A Washington Post article first posted online January 19th reported on January 18th incident at the Lincoln Memorial. Subsequent reporting, a student's statement, and additional video allow for more complete assessment of what occurred, it doesn't say it did, either contradicting or failing to confirm accounts provided in that story, including the Native American activist Nathan Phillips, was prevented by one student from moving on. And it starts talking about facts. And it goes on, and it says, a January 22nd correction to the original story reads, earlier versions of the story incorrectly stated or said that the American activist Nathan Phillips fought in the Vietnam War. Phillips said he served in the U.S. Marines but was never deployed to Vietnam. So they deflect and go off and start talking about Nathan Phillips. I mean, that was their recant.
They used the squirrel defense. Ooh, squirrel. Let's talk about Nathan Phillips. Let's not talk about what we did.
Right.
But the very end of it says the high school student facing Phillips issued a statement contradicting his account. The bishop apologized for statements condemning the students. And most importantly, Fred, they said in their thing of what made him change their story, subsequent reporting, a student statement, and additional video. So they admit in their statement that their reporting was incomplete.
Well, subsequent reporting. No, look at all the stuff. Look at all the video first. And maybe what they should have said is it's alleged. This might not, you kind of say it in a way that these are allegations, may not be true, but this is what this person's saying.
This reminds me of during the election cycle, any election cycle, you see this more where you have these people that are called fact checkers. Right. And so you have this, somebody will say something in a debate, and then the fact checkers will come out. And then you have fact checkers that check on the facts that show up in stories and whatnot. And my thought is, I'm sorry, I thought fact-checking used to be called journalism.
It's standard.
That's what they used to do.
It's standard editorial practice. I've been interviewed for a couple of major publications, and they would call me back and say, now, our reporter says this is what you say. Well, what? And I say, well, yeah, that's what I said, and that's what I meant. I mean, but they check.
But
ask the hard questions, right?
But let's jump on the journalist side. Nowadays, I think. Hold on. Boy, I didn't never do that on radio. But Cal, the main thing that has occurred that has changed journalism to the extreme is what you said, Cal, and that is. You have to. It's all about getting the first one out. And you look back at the Nixon case. You know, that, man, you got to get that out, be the first one getting it out. It's so fast now, Cal. They have no time to do full journalism because it's coming out no matter what.
They say, well, I saw it on Facebook, therefore let's run with what we saw on Facebook instead of vetting what we think we saw.
They don't have time anymore, Cal, to vet.
Think about it.
You've got to have it.
You got a guy for the Washington Post is being scooped by some Yahoo and his own individual blog. That's what they're up against right now.
That's exactly right. And there's not one or two or 10 newspapers that are going to get them. It's millions of people that are going to do it. So